Hello ladies and gentlemen, this is William Keat, and we're carrying on here with the series on the essentials of the British Constitution, using my document, The Occulted Powers of the British Constitution. We're using that as the basis for this, just to go through everything. And this is, I think, part 5, and this section is entitled The 1215 Magna Carta is Common Law, because there's a lot of confusion out there being claimed by not only people in the establishment, we know that, and the political class, but also, in fact, in larger portions of the sort of broader freedom movement as well. And I think we just need to nail some of this down. So let's get straight into it, and I'll deal with and expand on any issues that I think we need to. So here we go. It is important to address this issue that the 1215 Magna Carta is itself authentic customary common law, contrary to what members of the judiciary and legal profession will claim today. They will often make the claim that common law is case law or stare decisis, made by judges or justices. Although largely through ignorance, as already suggested, this will also in many cases be through a desire to misinform and obfuscate. It is in the interests of those in political power for the citizens to become hoodwinked over time about these matters, and the claim that common law is judge-made is one of the many distortions they have put in place. Okay, so let's just expand on this a bit, because this is really important. So this term common law is being used for two entirely different things, seemingly. And only one of these things is the genuine and real common law. Okay, and we need to understand why that is, and put some evidence for that, as I will in a minute, as to why that's the case. So one of those things is what we call the customary English law that comes from the late Saxon kings, from that English strain of law going way back, even before the 1215 Magna Carta, before the Battle of Hastings and the Norman Conquest. So we've got customary common law from back then, and we've got this other thing that sometimes is referred to as common law, which I would argue is not at all supposed to be called common law. And that other thing, which the legal profession sometimes use the term common law for, is case law. Okay, so this is the body of law that has come out of the appeals system, in which judges have written determinations into a body of law called stare decisis, which is actually very good, by the way. It's very interesting, and some very serious thinking has gone into that. And if you read it, you'll see that there's some very clever minds and some really good hard thinking has gone into that. So I'm not dissing it as a body of wisdom. The problem is that it's being referred to as common law, and therefore people are muddling up and thinking that that is the basis of our constitution. No, it isn't. Okay, and I'm really going to make this point strong here, that even people within the freedom movement are making claims that are kind of own goals. Actually, they're not realizing that the constitutional law is absolutely not stare decisis or case law, because otherwise you're giving authority to the very organisation that's meant to be subjugated beneath you. Yeah, and the key thing to remember here, of course, is that no future jury is bound by anything prior. Okay, so no law binds a future jury, and therefore the whole idea of case law, even existing as law, can't possibly be there. It's not that the wisdom can't exist. It's not that you can't have that body of knowledge about prior cases, because I think you should have that in some form. But that knowledge and that understanding should never bind a future jury, and is never constitutionally allowed to bind a future jury. And therefore one needs to understand and draw from that the true common law actually is legendaire, or the law of the land, which is this kind of law that comes from the English tradition of law. It's really important. Right now, we're going to look at two academic quotations from serious people in law, which will nail that down for you. Okay, so have a listen to these then. So this is starting with Blackstone in the introduction to the Great Charters, Blackstone's Law Tracts, page 289. So have a listen to this. It is agreed by all our historians that the Great Charter of King John, that's the 1215 Magna Carta, was, for the most part, compiled from the ancient customs of the realm or the laws of Edward the Confessor, by which they mean the old common law, which was established under our Saxon princes. It couldn't be clearer. So let's have another one. Moving on. So this is Sir Edward Coke, Chief Justice, Preface to 2 Cook's Institutes, page 3. Have a listen to this one. It, Magna Carta, was for the most part declaratory of the principal grounds of the fundamental laws of England. They, Magna Carta and Carta de Foresta, were for the most part but declarations of the ancient common laws of England, to the observation and keeping whereof the king, or the government, was bound and sworn. Couldn't be clearer, ladies and gentlemen. It's absolutely clear as to saying that it's the Magna Carta 1215 that contains the ancient common laws of England. We're not talking about case law or stare decisis here. It's this that is the foundation for our constitution. Yeah? So let's continue on. Otherwise this will become a rant. Clearly, as already stated, the judges are the members of the jury and not the government-appointed judge, as we call him today. A judge, a government employee judging on the justice of the legislation formed by the very organisation that employs him, could hardly be described as impartial. It breaks all the principles of a democratic and equitable rule of law. People's use of this term law of the land is ignorant and careless, because most people, including many who should know better, when using this term, are referring either to that which emanates from Parliament, which is legislation, or stare decisis, case law or precedent, authored by justices in the judiciary. They fail to understand, let alone make that distinction, that genuine common law is something else completely. The true law of the land, or legem terrae. Okay, so that section's actually really important because it is absolutely nailing down where our common law actually comes from and what it really is. And it's basically saying that the articles of common law that are contained within the original 1215 Magna Carta, which was not legislation, by the way, ladies and gentlemen, it was the promise that binds in perpetuity the government. Those articles of common law, that's what they're called, is the articles of common law, basically embody the constitutional principles that had been laid down for centuries prior even to not only the 1215 Magna Carta, but even before the Norman invasion and the Battle of Hastings, going way back into history. So these are absolutely sound constitutional principles that are expressed in the Articles of Common Law in the 1215 Magna Carta.